This week on Rochelle's Daily Wire Video Edition, we have another Supreme Court update. Any day now, indeed as soon as Monday, May 20th, we may have a decision from the Supreme Court in the Mission Product versus Technology case that's going to tell us whether or not the rejection of an executory trademark license bars the licensee from continuing to use the mark. And then probably in the last half of June, we will finally get a decision from the Supreme Court in the all-important Taggart versus Lorenzen case. And that's a real biggie because it will decide whether or not good faith is a complete defense to a violation or allegation of contempt of the stay. But what I want to emphasize right now is a brand new case reported this week in my column from the Fifth Circuit that I believe will end up in the Supreme Court in the next term and could be decided just about 1 year from now. The question is, do bankruptcy courts have jurisdiction over Social Security claims? Now, in years past, it was abundantly clear from the jurisdictional statutes that no federal courts had any jurisdiction, bankruptcy courts included, over Social Security claims until there was an exhaustion of administrative remedies. Then in 1984, Congress recodified the existing statutes, which were not intended to change substantive law. But as a result of that change, if you read the statute plainly, it seems to say that bankruptcy courts now do in fact have jurisdiction over Social Security claims, and for that matter, also Medicare and Medicaid claims that could be very important for hospitals and nursing homes. There was an existing circuit split going back to, I think it was 1991, where one of the circuits said, no, the codification canon doesn't apply, and bankruptcy courts have jurisdiction, but nothing happened until just really basically about a week ago, when the Fifth Circuit deepened that existing circuit split and said, no, in fact, there is bankruptcy jurisdiction. The so-called recodification doctrine does not apply because the statute is so explicit. And the Fifth Circuit extensively relied upon a book written by now deceased Supreme Court Justice Antonin Scalia, whom, as we all know, very much believes that the statute is the statute and nothing changes that. It's my guess that the government is not going to sit by and live with this decision from the Fifth Circuit, because if other circuits start to adopt the same approach, bankruptcy courts are very much going to be involved in Social Security claims. And by the way, I think it will also open the door for hospitals and nursing homes to force Medicare and Medicaid to fund them. Now, this is an extremely difficult topic, and we're only dealing, in this opinion, with basically scratching the surface. But as I said, it's my guess that the government's going to file a certiorari petition. It is possible that the court could decide as early as October of this year whether to grant certiorari. And if they do, we could have an argument sometime in the late or early winter, and that means a decision about this time next year. Well, this is Bill Rochelle, Editor-at-Large for the American Bankruptcy Institute, signing off for now. I'll be back sometime, same time next week, with another story on something important that has happened in the area of bankruptcy.